Morning, everybody. Yes.
Thank you, my lord. I'm calling case number 90, April 2025. The state here is Sultana and others. I stand in order. My lord, the state is in the position, unfortunately, today that I would have to ask for a postponement. I know that today's date was for a possible but it was also postponed the state to respond to further disclosure.
That would be made on behalf of accused or would it to be made by a certain date?
Yes, my lord, it was that following Tuesday.
Yes.
But the state did not receive anything, so I don't know what the position there is. Be that as it may, my lord, I've already canvassed the aspect that I would ask for a postponement to this court from my learned friends, and it seems that there were some resistance from some of the council. I will first hear from them their objection, and then I will respond to that.
Thank you. The accused may be seated. If I may just inquire from Mr. Lee before you sit down, what happened then in respect of the representations made on behalf of accused number 5?
So, my lord, the position is that when we went through the representation, we realized that count 25 did not form part of the representation, and that was brought to the attention of the defence team for accused number 5. They then promptly rectified that and also added an additional representation on count 25. So we are now in possession of both. I must say that they responded promptly, and it was forwarded to us, I think, on the same day that we brought it to their attention. So, my lord, there are certain aspects that are raised in the representation that we need to investigate further.
Yes.
We are busy with that.
How long will that take?
My lord, I would envisage not more than 2 weeks still.
Yes. Let me just advise counsel, the court was intending to at least have the pre-trials done by the end of this term.
Yes.
Now, 2 weeks is not going to be the end of the term.
My lord, yes, the end of the term is next week, Friday.
Yes.
If I'm not mistaken.
Yes.
My position is, unfortunately, and I know it's not the court's concern, my position is that I'm in the Randburg Regional Court for the whole of next week. So I am indisposed in any event. My lord, as I said, that is not this court's concern. If the court would not grant me my request for until early next term, then obviously I will have to rearrange my other commitments. My lord, the date that I proposed is that first week, and some of the council indicated that the 15th of April would be suitable for them. My lord, that is what I want to place on record at the moment. I just also need to place on record, my lord, if there are objections, the court needs to take notice of it, that every postponement up to now, from the 6th of February, was at the instance of the defence, either for consultations, or for representations, or for new counsel that came on board for accused number 5. So I think the state is not unreasonable when I make this request to this honourable. Thank you.
Yes, just give me a moment. Yes. Look, obviously, the court is not happy with what has transpired. The court has indicated earlier on a previous occasion that there's nothing stopping this court from holding a pre-trial in respect of several of the accused. You, Ms. LaRue, have indicated previously as well that in light of the fact that I believe it is accused 3 and 4, counsel having advised the court that her instructions are that no 220 admissions will be made, that you are not, the state is not going to seek any 220 admissions in this matter, and that you will then have the onus of proving everything. Mr. Which minute?
The pre-trial minute.
No. No. Mr. Sorry, give me a moment. Mr. Riviere, on the last or on a previous occasion, Ms. LaRue also indicated that whilst there were to be certain admissions to be made in respect of accused number 2, the fact that the state are not requiring any admissions to be made, none will be made, because the state in any event will have to prove everything. So what the court wants to know is, as the issue regarding the representations, well, I'll come to accused number 4, but why can the court, or why should the court not hold a pre-trial then in respect of accused number 2?
And what I can't see any reason why, and I've got the minute, I've got still a copy of the minute here with the date of the 26th of February, which was essentially the date that the state was ready with the pre-trial, and then it was postponed at the instance of the defense after we've received the request for further disclosure and the receipt of the representation.
Yes.
So I can hand that up to them. The state has signed it.
Yes, but do you hear what the court is saying? Can there be any prejudice to anybody if a pre-trial were to be held in respect of accused 1 and 2?
And 3 actually, because
Well, 3,
disclosure will not affect the
yes, yes, yes. No, you are correct. Let me hear firstly from counsel for accused number 1. Yes, good morning. Mr. Is it Mr. Hadebe? Yes. Yes. Yes, thank you. Mr. Riviere?
My Lord, I'm in the court's hands. I do not see with respect what advantage we're going to gain from doing the pre-trial piecemeal fashion, but if the court so wishes.
Yes. Yes, I hear you. However, is there any prejudice whatsoever to your client?
No.
Yes, thank you. And Ms. van den Heever, before we deal with accused number 4's lack of representation, as the court has been informed of, is there any prejudice in respect of accused number 3, in light of the fact that no admissions are going to be made, why a pre-trial cannot be heard in respect of him?
My Lord, there's a number of issues that has become quite pertinent to this matter. I'm just awaiting the arrival of my attorney because there's a large number of documents I want to hand up to the Honourable Court. Let me start off by making the following submission to the court, and it turns around this whole issue of a pre-trial. In this division, the Lordship quite rightly knows and appreciates a matter for it to be trial ready need to be certified. We've gone through the process of a pre-trial. We verily believe that we are deliberately being frustrated of finalizing this pre-trial before your lordship, and from getting this matter to go to trial by the conduct of the state. And please, I want to make it very clear so that everybody understands. I'm not pointing fingers at Ms. LaRue being the person who she is. I'm dealing with the state as per the relevant case authority said. The state encompasses the broader
Yes.
basis of
Yes.
the
No.
which includes the police.
Yes.
I intend to do the following. I need to take instructions from my client on certain issues, but let me just place some aspects on it. I do intend, in addressing your lordship, to hand up to your lordship the various requests and deal with the content thereof, so that your lordship can understand the relevance of it to the trial, and for you to certify this matter trial ready. That's number one. Number two, we were then informed by my learned friend this morning, quite controversially, I would say for the state having said previously we do not involve ourselves in DCS issues. And her words was, we're going to ask that it be transferred back to Cockstock at this point in time. So that's another issue that's now suddenly come up. And I can't help but get the impression that this is now punishment for us wanting to exercise our constitutional rights by asking for documents we not only entitled to, but we submit, and that's why I need to address your lordship on this with reference to these various applications, and say, the manner in which you as the state and the police deal with the matter when you bring it to court is you investigate, you collate your evidence, you put together a docket, and that docket should include everything that's needed for a trial. If you, for instance, have a bail application, and in the bail application you make reference to certain, let's call it expert or evidence that's as a basis have expertise, I would expect that you also have the necessary expertise that you would utilize before you present that request. So based on that, my lord, I am really quite astonished that the state cannot deal with the requests that we've made, because those requests are simple requests. It relates to items that I expect to be in a state's docket. When you arrest somebody and you bring that person before court and you stand up in court and say, I'm ready to go on with this matter to a trial stage, I expect those documents to be in the docket. And if necessary, my lord, I'm going to ask, as I said, I have to take instructions in that regard, that I present, that I'm going to ask that this pre-trial, that we present substantive evidence to this honourable court as to why this court should deal with this pre-trial in the manner that I'm going to suggest. But I am unfortunately a creature of instructions, and I do need to take instructions. There's been some issues on the road, and that's why my attorney is not here next to me. I managed to very quickly speak to him telephonically.
Yes.
And I also need to have certain discussions with the client to make sure that I take the correct instructions. Because where I'm standing at this point, speaking as an officer of the court, I intend to most probably invoke my client's right to a 342A and do it substantively at this point in time. Because I do not have to say, everybody that's present in court today knows what has been said about my client. Very unfairly so, I believe. And the longer this matter has been dragged out, and that black cloud hangs over him, we have an issue. How do you protect somebody's rights when everybody out there, without one iota of evidence, without anything objectively ever being presented, make these allegations? You have a right to defend yourself, and you have a right to do so speedily. You've got a right to a speedy trial.
Yes. So am I correct in understanding that you've made the application for documentation and that the state have refused?
No, we don't know what the position is at this stage, my lord, and that's why I believe it's so important that I address your lordship with reference to those documents.
Yes. Well, when was your application made?
The first application, I think, was done more than a month ago.
Do you have a date for me, an exact
That's what I'm
date?
saying. If your Lord, my attorney is the president. Look, can I ask for 2 minutes? I've asked him to bring documents that I wish to hand up to the court. It's very important for me. The court gives me the latitude or the opportunity to hand these up as exhibits to the court to address the Honourable Court on the issue of each of these applications, to take the court through what is in these, so that the court sees there's nothing controversial about the applications, there's nothing strange about the application. Those are items, again, I want to submit that I find every single day if I appear in this court, or in any high court division, or even in the regional, the district court, it's items I find in the docket on a regular basis. It's, as I said, but if I can ask the court's indulgence, may I have a short adjournment
Yes.
at this point?
Yes, sure.
I'd
But,
appreciate it. And then with relation to the representations, we made a very deliberate decision, having discussed that, Your Lordship, would recall I stood up at that point and said, I now have instructions to do the
Yes.
representations.
Yes.
Subsequently, having consulted, having looked at certain evidence, having looked at the indictment, we've made a decision not to continue with the representations.
Yes. I'm not questioning your attorney's conduct, but having advised the court on the last occasion, would it have not been prudent or proper or courteous or ethical to have just sent an email to the state to say to them, we have considered the matter, simply to let you know that we are no longer making representations?
My Lord, Your Lordship is absolutely correct. Blame us. We as a legal team will take the rap for that. We should have done that.
Because basically the state, yes, because basically the state is then held in limbo, waiting for the reps which never arrive.
But Lord, the case, our case, totally differs from the case of the other accused. The court, I've not heard my learned friend from the state saying it's accused false reps that controversially held us back from not being able to deal with the representation.
Yes, no, sure.
So that is not the case. As for courteousness, we apologize. But for the rest, the fact that we decided against making representation cannot be used as an excuse in whatever. And it's not the state's case, if I understand them correctly, that they're using that as an excuse. They just say we've not received.
Yes.
So,
but yes, but
so at the end of the day, my Lord.
Then at the end of the day, is your client accused number 4 prejudiced in any way? Should a pre-trial be held in respect of her?
That's the same thing, because it relates to I would like to address the court on both the issues, because some of the issues relate to that. That's why I said if the court would bear with me, just give me a short bit of time to properly address the court, because I truly believe that for the court to exercise its discretion at this point, the court needs to be au fait with all the relevant facts and see exactly where we're coming from as a defense group.
Yes, no, I understand where you're coming from, and I understand that you are going to address me. But my issue is, and please consider this when I adjourn, that you have indicated in the past that there are going to be no admissions. We're not talking about accused 3 now, we're talking about accused number 4. There are no admissions in respect of accused 3 and 4 who you represent. In respect of accused number 4, there are no representations pending, and they are not going to be brought.
So let me just address the court on that. The issue is the court cannot certify the matters being trial ready. We say, for us to run this trial, these are the documents that we believe is vital for the court to run. This court knows what's happening here every single day. Matters are certified trial ready, the case starts, and suddenly there's a whole set of documents that's not available. It's in nobody's interest for a case to start and stop piecemeal being dealt with. We need to have certainty on these documents. We say these documents are documents we need for this case to run. If those documents are not available, then the case cannot run.
Yes,
But
but
we've also at this point, my Lord, there's a second issue that has arisen in the past week. I say we will have prejudice at this point, but I've in my mind, I've got a different way that I think I might circumvent or suggest to the Honourable Court how we can circumvent this impasse where we are right now. Because I believe, as the Honourable Court does, that this pre-trial needs to be concluded as a matter of utmost urgency.
yes,
And we have to deal with it, and we have to come to some kind of agreement on that.
Yes.
And it's for that
And
reason.
let me remind you, Ms. van den Heever, you yourself have stated on more than one occasion that having regard to the fact that your client accused number 3 is in custody, it's to his detriment, he is prejudiced thereby, and the intention is to get the matter to trial as soon as possible.
And that's why we've done whatever we could to make sure from our side what we believe is necessary for this court, for our clients' rights to be protected, for this case to run. We've done what we've needed to do, and that's what I would like to address the court in on with an opportunity.
Very well. Will you let my registrar please know when you are ready? The court adjourns.
All right.
May it please the Court. My Lord, first of all, we indebted to the Honourable Court for the indulgence. My Lord, I have prepared, my learned friend has got a copy of the said application. It consists of some 16 pages. This one is unsigned. I beg leave just to hand the copy of the application for disclosure up to the Honourable Court. On the 26th of February last month, that's the date of our last court appearance, this was the document that was served on the state, in which we asked for disclosure of certain documents. My Lord, I'm going to go through it very briefly, just so that your Lordship gets a bit of understanding of where we come from. There's an introduction, and we refer to the fact that the accused are before court, who we act for, what the charges is. We then deal with the fact that there's 3 dockets that's important in this particular matter. Then in respect of, on page 2, in respect of all the dockets, we then deal with the devices that were seized from any of the accused here. And we ask under paragraph 6, my Lord, 6.1 to 6.16, simple things like the owner of the device, the metadata, the lab intake documentation, acquisition documentation, etc. And then, of course, very importantly, my Lord, I'm not going to go through each of those items. As your Lordship know, when you seize devices, whether it's a computer or a cell phone, and you extract, you either mirror image or extract the data from it, you normally have in your docket an affidavit by the expert. That is right. Now, there is no such affidavit whatsoever pertaining to these devices. So, one of the things that we ask the inter alia, forget about all the other issues that we deal with, but we want the actual affidavit that relates to the devices, any of the devices. And I'm not going to go into details as to what the state allege in this matter, but I have never been, and I would, in my experience, and I think my learned friends sitting with me, normally if the state sees devices and rely on it in the docket, there's an expert report in the docket. This is not there, so that is one of the issues or the items that we ask for. So we also ask, my Lord, because normally in these kind of cases, do you provide it with a mirror image that's made? So let's say it's a telephone. They do a mirror image of the phone. The expert provides a report and says the mirror image has been made of the phone. He gives you the dates, etc. He gives you his expertise, and then he continues and he says what is on the mirror image. And the reason why this is of importance, my Lord, so your Lordship understands, and I know your Lordship won't deal with the trial, so that's why I've got no hesitation in place. We've got Andrea.
Well, there's no certainty that the matter won't be allocated to.
Yeah, but at this point, my Lord, I think because of certain issues.
But if I may just interrupt you, has the state responded?
No, not even an acknowledgement, but let me just quickly go through. The reason why these devices, especially vis-a-vis, so I said, it's common cause, my Lord, that devices were seized, I think, from all of the accused before court. It's common cause that devices were seized from my clients. When it comes to the device that was seized from accused number 3, the issue here is, and this is all over the media, that when IDAC, Andrea Johnson, the head of IDAC, gave evidence at the portfolio committee in Cape Town about the seizure, she stated under oath that by the time, days later, I think weeks later, when they received the device of accused number 3, it was still on, it was working. And that her expert, when he was downloading it, complained that there were information that were deleted from the phone. So there's serious controversy about what transpired vis-a-vis this device. So that's why we say we're entitled to this information. Let me move on, my Lord, from that. We then go directly to the Sampton, that your Lordship would find on page 5. We then, with a reference to specific statements, A5, 6, 7, and 8, there's extracts that's quoted in these documents. We say, where do you get these extracts from? So all we're asking is, if you have an extract from a document in a statement, you must explain where you get the source of the document. It's as simple as that. So, and that I would expect to be in the docket itself. Then there is...
So are you saying that in respect of all these issues, there has been no reply?
There's been no response whatsoever. There's no explanation provided as to... we do not have this...
Or we have it and...
Or we have it, you're not going to give it to you.
Yes.
Or, and,
but what has that got to do with this?
but let me... your Lordship must understand, and I've just given you one example when it comes to the devices. Now, your Lordship says, okay, if you challenge everything, then I don't need to go through a whole process, but I say you need to set the matter down for trial. You can't set it down for trial if I don't have the information that's contained in here, because it affects the allocation of the court case. So your Lordship can go through this yourself. There's documents in there that's not even in the form of a statement. I respectfully submit, my Lord, if you look at this, you will see why we say the state is, well, I can only surmise that there's a deliberate either lack of expertise in the investigating team when they put together a docket. That's why none of this is in the docket. Or
alternatively, it's malicious.
Alternatively, it's malicious. And so I'm going to move on to this. The second issue that we've dealt with, my Lord, my attorney, and here we've provided the Honourable Court with a string of emails that relates to this. It relates to my client made, on the day he was arrested at approximately 2:30. He's then taken to a police station contrary to the Criminal Procedure Act, prescripts, there's standing orders, etc. And for more than 12 hours interviewed by this investigating team. During this interview, he's refused access to lawyers, etc. It's now subsequently come out that during this interview, this 12-hour-long interview, the interview, which is in a form of a statement, questions asked, is recorded and later reduced to writing. We learn of that, we ask, please give us this. We then get the following response from the state. The state basically says to us, we've attached it here for your Lordship's benefit. It says, in short, it says that we do not have this statement in our possession. That's a statement. This is now the day we arrested on this particular case, on a warrant of arrest. We then said, if you want to obtain whatever is made available, go to the Matlala Commission or wherever it is. It goes on, it says, nothing in the whole interview forms part of the police docket currently before court. This is immaterial, my Lord, whether it forms part of their docket or not. Section 335 of the Criminal Procedure Act says clearly that any statement made by my client, I'm entitled to it. And that is what boggles my mind, to put it plain bluntly to the court, that in the face of Section 335 that says I'm entitled to the statement, I'm not given the statement. It was recorded and reduced to writing. It goes further than that, my Lord. It was reduced to writing. That is common cause, I think, to everybody concerned. In fact, if you read what the state response is, it's also common cause to them. So, my Lord, this is the frustrating part that we've been dealing with. As we want to push this matter ahead, this is what we're dealing with. But whilst your Lordship, as what we now have done during the adjournment, we took instructions. And this is what my instructions are, my Lord. Knowing the content of this docket, as far as accused number 3 is concerned, there's 2 statements only in all 3 dockets that directly implicate. No, in fact, I'm lying. 3 statements. There's one of DJ Vetti. There's 2 statements made by him. And there's a statement made by a lady called Papu. My instructions are the following. We are prepared to admit the state's case in toto. In other words, we will not challenge the ballistic expert, none of the normal aspects. Any witness statements where that is objective and proper evidence, state can hand that up. We're happy to do that. All the state needs to do is call these two witnesses. In other words, that make these three statements. We believe the witness Papu, we know, my lord, that's strike. It's all over the media. She can't.
So you're saying the state needs to call the two witnesses
To call basically
who made these three statements.
who made these three statements. So, but it goes better. The witness Papu, who purportedly on the one statement says that my client told her to do something, subsequently went to IPID and said the statement that's in the docket is a false statement. They forced me to make the statement. And there's objective evidence that we've asked for in the form of tracking devices that show that what she says is not correct. So my instructions are the following, my lord, that my attorney wishes, together with the state, to approach either the judge president or the deputy judge president in this division and inquire about the allocation of an urgent trial date. We will ask for a separation of trials. We do not believe that it's in the interest of my client to further be detained, because this is the issues that is related to my client is so limited, my lord, that this matter can be concluded literally in a question of 2 days, maybe 3 days. But there's a further reason, my lord, and that is relates to serious security issues in this matter. And I'm not going to place this on record. That will be dealt with. Threats, and because of that, the defense has decided we don't have the benefit as the prosecutor of having an entourage of security guards that go around with us. We believe that it is in the interest of justice and everybody's, and maybe the defense safety in this matter, that this matter be dealt with as quickly as possible. So that everybody out there can see, as we believe, is demonstrated objectively, in which we will demonstrate that there's no case to answer at all. So what my instructions are is to ask either that we roll the matter till tomorrow to see that they can work out between them, because I don't want to be, I'm not normally part of those kinds of, the attorney deals with it, that the DJP, as I said, or the judge president himself be approached to see if there's a judge available, if it can be allocated, because that would be our starting point. Can we get a judge to hear this, that we can take and allocate maybe for a week at the most to hear this matter on an urgent basis? And if that is so and it can be done, then of course we'll have to bring an application for a separation and argue the separation. And we have to serve notice, of course, on my learned friends. We do not, well, I can't foresee that any of them would have objections in that regard. There's a number of other issues which I think would further support our case for a separation based on current case law. But that's where we are. So what I'm saying to your Lordship is, I'm prepared to forego this whole normal process. My instructions are that my client believes it's in the interest of justice that we cut through the chase. We run this case with the two witnesses that he believes are pertinent in this matter. Any other witnesses that makes reference, we know the normal, the doctor's reports, the ballistic, we'll admit all of that. If there's witnesses that says X, Y, and Z happened, we'll admit that. When we're not prepared, and that I will make very clear, because we believe it's inadmissible evidence. The opinion of some police officers is, in my opinion, it was a hit that was organized. It's impermissible in any case, and inadmissible. So that is what my instructions are at this point. May I please? Sorry, my Lord, just hold on one second.
In respect of accused 3 and 4.
We're quite happy for accused number 3 because of the allegations that fall to be part of that. But if for some reason the state believes that there is that they need to do something else with her pertaining to the indictment because of the controversy on one of the charges, she's out on bail. We'll deal with her case in due course. But as far as accused number 3...
So this is in respect of accused number 3?
Yes, my lord. If necessary, we can do it, as I say, for accused number 4 too. But right now, my main concern is the person that's in custody. May it please the court.
Yes, my lord. I just want to, in the first instance, say the state takes exception to any allegations. It's by the media that's crawling around here on the floor, my lord.
Okay, well, please, this is a court. Just, if you're going to sit on the floor, sit the way that I can't see. Please, thank you.
My lord, that the state takes exception to any allegations or any insinuations that we are maliciously withholding information. The fact of the matter is, my lord, if your lordship will look at this document, your lordship will see that in the first place, that what is requested here, especially in paragraph 6,
Yes,
is with regard...
To be very honest with both counsel, I'm not going to look at this document, because this document is not pertinent for the reason that we are here today.
I agree with your lordship. I just want to place this on record, my lord, is that even before the 26th of February, I've been inviting the council to submit this document that we've received belatedly after the adjournment on the 26th of February. Up to that time, when we arranged the date of the 18th of March, specifically placed on record, I have not seen this document, so the 18th of March, which is today, may be not sufficient time for the state to respond. The fact of the matter is, if I can just place this on record, that the information that my learned friend requests relates to cell phones that is after the fact, after the incident of the in 2023 that he is charged with. So it doesn't relate to the case. It is irrelevant. But be that as it may, my lord, if we have it, we will provide it. The fact of the matter is the interview that she's referring to is also a statement made by accused number 3 containing sensitive information that is currently under investigation and that we will not disclose at this stage. It is not in the interest of justice. So that being said, my lord, I maintain my request that we postpone this matter so that I can attend to the request for further disclosure. As with regard to the request for separation of trials, my lord, that will certainly also be opposed because it is not in the interest of justice that a criminal trial be run piecemeal.
Any response?
My lord, if the court would just... my lord, I see my learned friend has not addressed the issue where she told me that they're going to ask that it be transferred to Kokstad. Maybe she must just address that issue too. I'd like to know why I was informed that there will be an application or that my client will be transferred to Kokstad.
Most certainly, my lord. My lord, the court will remember that on the 6th of February, this court made a ruling that was very limited to allow access to accused number 3 by his legal team for, I think it was until the Monday or the Tuesday after the 6th of February.
It was both days.
Yeah, so the Monday and the Tuesday. So that court order has now lapsed. That's correct, sir. There's no reason for him now to be held further. She herself placed on record there are threats, and I can only imagine what kind of threats are made. And I'll place it on record if she doesn't want to place it on record. There are concerns for the safety of accused number 3.
My client. I want to make that very clear. There's no threats made against my client.
So, my lord, I persist with my request that the J7 will be made out for Kokstad today. That was the arrangement from the beginning, that he's only brought here at the instance to allow for access to the client and to make consultations easier. There's no reason why it cannot be transferred back.
My Lord, maybe let me just place on record, we did contact DCS during the adjournment. The fact of the matter, DCS says they will not be told by a prosecutor or anybody else when to detain the client. He will be further detained at Kgosi Mampuru. He's not being transferred to Kokstad, and that comes apparently from the commissioner, the area commissioner himself. So he's staying here. That's the...
For hypothetical reasons, let us assume they changed their mind this afternoon and you decide to transfer. Obviously, you know what your remedy is.
Of course, my Lord. That's why I needed to ascertain this fact, because I was intent on bringing an urgent application now by putting my attorney into the box with a notice of motion. But we've ascertained from them he will be detained here. DCS decision is he will be further detained here and not be transferred to Kokstad.
Ms. van der Leeuw, the court is indicated. The court is not concerning itself with the documentation ended up. And whilst the court is surprised, but obviously amenable in having justice expedited by your suggestion of a separation of trials, of this trial in respect of accused number 3, possibly number 4 as well, possibly lasting 2 or 3 days, you admitting all the formal admissions, etc., and other admissions, that has got nothing to do with this court. So, what this court intends to do, look, obviously, you know what your rights are better than most counsel, and you can pursue anything you wish to. But having regard to the fact that the state has not requested or is not requiring that any admissions be made, counsel for accused number 1 has indicated he's ready to proceed with the pre-trial. The same as counsel for accused number 2.
We're going to do so with the reservation of our rights, of course, at this point in time, my Lord, because we will deal with that. So we can continue with the pre-trial as far as my clients are concerned too.
Yes, thank you. And obviously, the court encourages you to pursue what you indicated regarding approaching the office of the JP or the DJP with regard to expediting the trial, separating and expediting the trial in respect of your clients.
We intend to do so, my Lord. That's the only solution we see at this stage to get this matter, because
it's admirable and it would appear to be in the interest of justice. What they decide or determine is another story.
Of course, each case will be treated on its own merits, my Lord, and that's what we will do. Deal with such an application based on what we believe is strong merits. May it please the court.
Yes, thank you. That leaves us then with accused number 5. Ms. LaRue, you will have noticed that this court has been extremely accommodating to all counsel and all accused in this case. I don't want to interfere with your schedule next week. However, of the view, unless you can persuade me otherwise, that I put the NPA on terms with regard to the representations made in respect of accused number 5, and that they respond, I'm looking at by the latest this coming Monday, and that in the course of next week, a pre-trial be heard in respect of accused number 5. Bear in mind that the pre-trial, literally for a single accused, will take 5 minutes. So I'm even prepared to arrange, accused number 5 is on bail, that the hearing be heard at 9:30 in the morning on a date that suits you and the counsel. But I'm of the view that it's in the interest of justice that the pre-trials regardless of what happens thereafter, what applications may be brought, etc., be finalised before the end of this term. And it will then impact for possibly half an hour on one of your days that you indicated you are busy in the lower court. And you are aware as well, I don't need to add, that this court takes precedence.
Of course, my lord.
You know,
Yes, my lord.
so that is where I'm looking.
That's good, my lord. So
What do you say about it?
So, my lord, no, of course, I'm
It's
not going
been
to.
3 weeks.
Yes.
I understand you indicated to the court on the last occasion that reps had been handed in or delivered on that day of the hearing. That was
Yes.
3 weeks ago.
Yes, my lord.
You know, justice needs to be done. Justice not only to the accused, but to society, to the state, etc., to alleged victims and their families. So I don't think I'm being unreasonable, and you indicated that it was in respect of one count that the
Yes.
NPA had not
Well,
considered.
Well, maybe I should just put that in clearer terms. All counts are being considered. It was just that the one count was submitted to us afterwards, after the.
But is 3 weeks, well, it will now be 4 weeks. Is that not sufficient for the NPA
My
to
lord,
say yes or no?
I will consult with the investigating team and see what we can expedite.
Well, I'm going to make an order in that.
Yes, my lord. No, that's fine.
Thank you. Yes, thank you. So we will then proceed to hold the pre-trial in respect of accused 1, 2, 3, and 4.
My lord, can I hand up to my lord then the pre-trial minute? I actually note that counsel for accused number 1 and 2 already signed it on the 26th of February, and then the court handed back to me
Yes, you say that is in respect of accused
1 and 2, my
1
lord.
and 2.
Yeah.
Hand that up in the interim. Do counsel for accused 1 and 2 still maintain that the document which they signed, I understand on the last occasion, stands?
Indeed, so, my lord.
Thank you. Mr. Premier?
I confirm, yes, my lord.
Thank you.
As the time is, sorry to interrupt, is the court going to give us, in respect of accused number 5, an opportunity to make certain submissions? I've heard what the court has said, and the court, I've gathered that the court is amenable to granting a postponement, but we wanted to make certain submissions in respect of this very same request by the state for postponement, in respect of accused.
Yes. Let me deal with the other matters first, and I will come back to you.
As the court pleases.
Thank you. Because remember, we are not dealing with the trial in any event in respect of the trial.
Indeed so, indeed so.
Thank you. Well, this appears to be a pre-trial in respect of all of the accused.
My lord, yes, that was the previous minute. May I suggest that your lordship just then just make a note that the pre-trial is not held in terms of accused number 5. Otherwise, just delete accused number 5's name from the minute.
Yes, but I see that it is signed by counsel for accused 1 and counsel for accused 2.
That was signed on the previous date, my lord.
Yes.
Yes.
Okay. with the consent of council, I will formulate this in a single minute ultimately. But I'm going to, for the purposes of this minute then, may I make a suggestion, please? This is going to be cumbersome in light of the fact that this document, there's a lot of writing on it, and it reflects accused, all 5 accused. Can I request that the matter stand down and that you prepare a minute with today's date for today in respect of accused 1 to 4?
I can do that, my lord. It's no problem.
Please.
Yes.
And then we can proceed to deal with pre-trial in respect of accused 1, 2, 3, 4.
As the court pleases.
How much time will you need?
My lord, half an hour at most.
Yes, very well. Let me then hear what you wish to submit regarding accused number 5.
As the court pleases, the court would note that on the 26th of February when we were here, we submitted our reps in respect of the other charges.
Yes.
The state then, before we left the court building, indicated that we did not make reps in respect of charge 25, which we did. And
subsequently do.
Yes, we did. Then we submitted it. We did not submit it really on the first on that day, but I think the day in which the court has made an order that the reps should be made available for accused number 3 and 4. We then submitted our reps. That would have been
on the Tuesday, the following
the Tuesday, the 3rd of March. The court has said something as it was deliberating, that this amounts to justice delayed is justice denied. There is no reason. In an actual fact, when the state spoke to us, they said they needed only 2 weeks to give us a reply on the reps.
Yes, it became 3 weeks, if my memory serves me correctly, after counsel for accused number 4 indicated that they would also be furnishing reps in respect of accused number 4.
I agree with the court, but unfortunately that doesn't change the price of the bread, because they said they wanted 2 weeks in respect of our reps. With considering the submission that was made by the legal representative for accused number 3 and 4, it then extended their request to 3 weeks. And in 3 weeks, they cannot say now, because I hear my learned colleague, it's something that she wants to insinuate, though she's not saying it outrightly, that the reps in respect of charge number 25 were made at a later stage. It cannot really be at a later stage.
Yes, but she did say that it was timelessly made.
Indeed so. But be that as it may, given the fact that they needed 2 weeks, which then was extended to 3 weeks, I am amenable to a postponement, but I wanted this court to note that in an actual fact we intend today to bring an application in terms of Section 342, capital letter A.
But I've just explained, with respect, counsel, I've just indicated that I intend making an order, putting the NPA on terms that they reply by Monday.
As the court pleases, I just wanted to indicate our displeasure with the fact that we could not get the response by today.
Thank you. And we also need to bear in mind that, and I'm saying this in all fairness, that it is not up to counsel for the state, Ms. LaRue, to agree or disagree. When representations are made on behalf of an accused. This goes to her superiors.
That I'm aware of.
Yes.
That I'm aware of.
Yes.
But there are also timelines.
No, absolutely.
Yes, and we need to stick to the timelines. That's the court pleases.
And this is not a rocket science matter, looking at the indictment that would require an extended period of time for the NPA to agree or disagree.
It is not, madam. More especially in respect of accused number 5. I mean, if you, it didn't take us even a month for us to look at the docket and to decide that they were going to make representations. And this should suggest that this is it's not a rocket science matter. I mean, it's a matter that the NPA has investigated for quite some time, and the NPA by now, they should be knowing what is their position in respect of accused number 5.
Hence, I indicated that I intend to refuse the state's request for dismissal.
As the court pleases.
The court will then adjourn. You will please let my registrar know, and then you will, if I can ask you please to prepare a minute in respect of accused 1, 2, 3, and 4, with the, obviously the relevant counsel's details, etc., and you can then proceed with that trial.
Yes, my lord. I can be here before 1 o'clock. If we can do that.
It won't take too long.
No.
Also, can counsel for accused number 5 then, and then I can excuse you. Can you give me a date next week as to when we can do it for the trial in respect of accused number 5?
My lord, I would suggest the 25th of March, Wednesday.
Lord, may I quickly approach my client?
The 25th of March is Saturday.
Yes. Would you like this to be done at 9:30 if it suits you? It's 10 o'clock. Okay.
10 o'clock is okay for me.
It will
Yeah.
take a few minutes.
True. No, that's fine, my lord. 10 o'clock is fine.
Thank you, yes. Accused number 5 may stand. Thank you. Then, in respect of accused number 5, Ms. Mzama, your matter is postponed for pre-trial to next week, Wednesday, that is the 25th of March, 2026. You are on bail and your bail is extended and you are warned to appear on that date. Furthermore, in respect of accused number 5, the NPA is ordered to respond to the representations made on behalf of accused 5 by close of business on Monday, the 23rd of March, 2026. Palmer, you are excused, as is your counsel, and we will adjourn then for a half an hour and proceed with the trials in respect of the remainder of the court adjourns.
Katie, you can stay here. I'm quickly going to run and just print a new
in the trial within the trial.
In respect of accused 3.
In respect of accused 3 and 4. And I can also place on record that there's going to be challenges pertaining to any statements made by him after his arrest based on his constitutional rights, judges' rules, etc. We'll also challenge the admissibility of any of them.
Yes. So the first one is challenges in respect of, is it electronic items seized?
Let's call it the search and seizure in respect of any electronic, let's call it devices. Let's make it simple. We use the Cyber Crimes Act words also. Devices.
Search and seizure in respect of?
Devices.
Of what?
Devices.
Oh, devices. Yes.
That is, we're going to challenge though that. And then we will challenge in respect of statements made by accused number 3 subsequent to his arrest.
Yes.
As I've already said, yes. And that's with regard or having regard to judges' rules, his constitutional rights, etc.
Yes. Thank you. I see the estimated trial duration is 25 days.
That's correct, my lord.
Is there any audio or video footage in this matter?
There is indeed, my lord.
Which is it, both?
Both, my lord.
Video and audio footage. Are you in a position to specify, is this in respect of all the accused or certain, or are you able to specify?
My lord, it's difficult to specify because it's with regard to crime scenes.
Okay. No, that's fine. Ms. LaRue, is there any other issue or factor you wish to raise regarding trial readiness?
My lord, at this stage, there is none, bar the application for further better disclosure.
Yes. But that will take its course.
That will take its course.
Yes. Mr. Hadebe, in respect of accused 1, are there any issues that you wish to raise relating to trial readiness?
There are no issues, no.
Thank you. Mr. Gruvier?
Nothing at this stage, my lord.
Ms. van den Heever?
My lord, I have already indicated to your lordship those are the
Yes.
issues that is at this stage quite contentious.
Yes, thank you. And when is the trial date?
My lord, nothing comes easy in this case.
Yeah.
So that is definitely something that's still contentious between us.
Yes.
The date that I propose, my lord, is the 18th of January next year, the first day of the first term.
18th of January 2027.
That is correct, so my lord.
Why so late?
My lord, the position is the following, is that accused number 1 and 2, and the defense counsel is well aware of that, is involved in another matter that we will also then run from the 4th term. It will take up the last portion of the 4th term from the 27th of October.
Yes.
So
But, yes.
that's the one reason. My lord, it's with the date on the 3rd term also. And I must just add, I've been trying to locate the role planner
Yes.
this morning, and it's been quite a challenge because I know they're busy with some meeting. I've just sent you another message. So I'm not quite sure about the dates of the third term. Previously, it was sort of available. The only challenge that we have with the third term, my lord, is the fact that the person, and I spoke to him this morning, is only available certain dates
Of the third term.
in the third term.
Yes.
And there are portions where he is indeed in Benoni High Court, etc.
Yes.
So he is more of the availability of the council.
Yes. Did you wish to say something?
Indeed, so
Yes.
my instructions are that the trial really can take place within the term. We did call advocate 1%. He did avail himself. He's probably not available from the 7th of August, I think, until the last week of August. The third term begins 20 July, ends in September. The trial can start 20 July, and for the time that advocate 1% is not available, then we can adjourn. And probably as soon as the 31st of August is available until the end of the third term, then the trial can run. So the trial can be really heard in the third term. And I've explained that to my client. My client doesn't have an issue with that.
Yes.
Rather we lose a week for advocate Ryan Pressing than to have the trial be heard next year. My client is
Yes.
number one, has been in custody now. He has been denied bail for reasons that have been published in the media, however.
Well, from what I understood, not in this matter.
He's on warning for this.
Yes.
He's been in custody for
Yes.
we must be dealing with nationality improvement, my lord. So an expedient and a speedy trial is what he wants.
Yes.
That's
Thank you. Let me hear Mr. Crouvier.
Please support, my lord. My instructions are also to endeavour to arrange the earliest possible date for the purposes.
Yes. Thank you.
Thank you.
Ms. van den
Needless
Heer.
to say, my lord, to say we vehemently object to this matter being postponed to next year. This is just wholly unacceptable.
Yes. Ms. LaRue, you, from what I understand, you were waiting to hear from the role planner regarding the third term. But you're saying that the fourth term is out because accused number 1 and 2 are involved in another matter. Is this other matter, may I just inquire? I don't want any details, but is this being heard in the High Court or not?
That's correct.
In this High Court? Yes. As you are well aware, as all counsel are aware, things happen, and there is a possibility that the trial may not even, their trial, accused 1 and 2, may not even proceed for various reasons. The court understands that you are awaiting feedback from the role planner. Can we not arrange a date in the third term in accordance with what counsel for accused number 1 has indicated regarding Mr. Gissing's availability, and take it from there?
Yes, my lord. My lord, may I just also remind your lordship about another matter that we postponed for the same reason that I'm also involved in, and I am,
Before me?
my lord,
No.
it was just,
Oh, a postponement.
yeah, my lord,
Yes.
your lordship will remember there was the Nguri matter,
Yes.
which was also postponed
Yes.
to a date in the third term, and I see now that I've actually,
Did that not involve the council in Durban and so on?
that's that matter, my lord.
Yes.
So, my lord, I am increasingly spreading myself
Yes. Thin.
even more thinner. So, but be that as it may, we can do this. And
Yes.
we must see which one is
Yes.
going to proceed.
Yes.
Yes.
I think that is a good idea, because if my memory serves me correctly, the senior counsel from Durban, there were issues relating to him being employed by the state as a counsel in a very extended matter. That's why they even requested a trial date in sometime late in 2027. So I think let us then, in the interests of justice, postpone to the third term.
So, my Lord, may I then suggest then the 20th of July, which is the first day of the term?
Did you indicate, Mr. Hadebe, that your counsel would be available then?
We had a conference call with my
Yes.
from the state. He is available.
So it's only for a week or so in August. Yes. Are all counsel happy with that?
My Lord, we will avail ourselves on that basis.
I'm available, thank you, my lord.
Thank you. That leaves then counsel for accused number 5. But you will use your necessary skills to apply pressure upon counsel for accused number 5 to be available also. When we deal with, I mean, we don't know. Maybe the state decide to withdraw the charges against accused 5. But we will know next Wednesday. Thank you.
My Lord, maybe there's one last issue, if your Lordship don't mind. Maybe we could also do timelines pertaining to the disclosure issue. Otherwise, because we now already
Yes.
going in, and your Lordship knows from our experience in another matter, unless the court gives timelines, this thing just gets pushed and pushed and pushed. That
Yes.
same matter that your Lordship was in, we're still dealing with disclosure issues, and we were set for trial on the 2nd of February.
And I understand representation issues.
And, my Lord, the
Yes.
representation issues, and.
Yes.
So the only thing that I have learned, maybe from
Yes.
experience, unless there's timelines set, and that's what
Yes.
His Lordship also did in that case, is strict timelines.
Yes, very well. Miss Leroux, I think there is merit in what Miss van den Heever has stated. So let us, these are the timelines in respect of
So
this request.
So the application for disclosure, that one, my Lord, we need to set the timelines in. We intend with regard to the issue of the client's statement, we're almost ready, we've prepared a substantive application to compel disclosure in that matter, because it's totally different
To
with
these-
this one. So that
yes.
one will be served and dates will be arranged with
Okay.
the DJP in that respect. But that one, I respectfully submit, we need to keep timelines.
Yes. Yes. What do you suggest? The court appreciates that it is a rather voluminous document.
Yes, thank you, my Lord, for the understanding.
Yes.
So, my Lord, may I suggest then the 7th of April?
My Lord, I will just take it at this point. It's better a half a loaf of bread than no loaf of bread at all. So may it please the court.
Is that white bread or brown bread, Miss van den
Well,
Heever?
look, brioche is my preference, but I will not go down that route. Maybe I'll get accused of insisting on getting cake rather than bread.
Yes, that's wishful thinking. Yes, I think that is reasonable in the circumstances. Yes, Miss Leroux, we all have to work through the recess anyway. So, yes. Thank you. The accused can stand. if I recall, you indicated previously you all understand English. Is that correct? Yes. Simply then to advise you that the pre-trial in your matter has been concluded. Your matter then is postponed for trial to the 20th of July 2026. Accused 1, 2 and 3, you're in custody and to remain in custody. Accused number 4, you're on bail. Your bail is extended until that date and you are warned to appear. The court wishes then to add that in respect of a request for information and documents made on behalf of accused 3 and 4, the state is ordered to reply thereto by close of business on the 7th of April 2026. Are there any other issues?
I confirm, my lord, thank you. Nothing else from our side, my lord.
All good.
My lord, Mr. Kruger just made a very important point.
Yes.
If the state refuses disclosure on certain documents, which
Yes.
I already foresee we're going to go that route,
Yes.
should we not provisionally then have a date available for argument, or for us to then file the actual application? If the lordship knows, I guess you bring an application to compel, there's an answer and a date. So I think we need to also just keep that in mind. I don't know.
If we're going to, well, if this matter is going to proceed in the third term,
I'm wondering.
should we not set the matter down as a provisional date?
That's what I was thinking. Maybe it's a good idea that we choose
Yes.
a provisional date in the meantime.
Yes.
Because, Your Lordship, I'm one of those counsel, I'm very pragmatic when it comes to issues of disclosure. But what I believe I'm entitled to, I want to argue that. Other issues can be dealt with.
Yes.
But in the meantime, if we can arrange for a provisional date, potentially for argument to compel. I don't know if my little friend wants to suggest a date at this point in time.
Well,
I think if we go to the beginning of May, my lord, that gives us about a month. It's more than ample time to file applications to compel, to file an answer there, to do a
Yes.
reply there, to do that in very
and then
short-
to have the matter set
and
down
we
for
set it down
argument.
in May,
Yes.
then for argument already.
Yes, maybe that is practically a good suggestion. Yes. The beginning of May.
I want to suggest 7 and 8 May, my lord. I've got a matter that's been coming for years, unfortunately, in the Free State Division that I need to deal with. I would suggest 7
Yes,
and 8. if
but
that's-
oh, you mean in the meantime you will have prepared
everything
your
will be
application?
prepared and ready, so it's literally a question
Yes.
of it being ready for argument on that day. We undertake from our side, we've done this exercise, as your lordship knows, so it's actually not a very difficult process.
Yes, obviously bearing in mind that this matter may be allocated to another presiding
Yeah,
officer.
of course, my lord, the
Yes.
DJP can decide to allocate it to somebody specifically
Yes.
to deal with. But your lordship would also know from that time to
Yes.
get a date at the point when you want to now argue, it also becomes an issue. That's why I want to suggest 7 and 8. My attorney, I will ask him to make contact with my little friend for the state, that the arrangements be made timeously for a judge to be allocated to hear such arguments.
Yes.
May I please?
Is that in order with you, the 7th and the 8th of May?
7, so both days.
Yes.
7 and 8 is fine.
Okay. Must the court then recall its order in respect of accused 3 and 4? But they don't need to be in court.
Actually,
These are applications.
They actually shouldn't be in court because it's part of, unlike other applications, that should be, for some reason, we just skipped that part on the last occasion, my lord. But I think because of the unique situation that was at that point
Yes.
dealt with, there was no need for SEEM to have them present at that point. But in terms of the provisions of the Criminal Procedure Act, when you
Yes.
bring an application to compel the accused must be present
Yes.
to be involved in.
Yes.
That should then be all the accused.
I beg your pardon?
They're all riding on this request, so I would imagine they all.
No, the request is made on behalf of accused 3 and 4. There's been no indication that this request is also being made in respect of the other accused. But obviously, the council are welcome to attend. I mean, it's not necessary, though, in light of who the proposed applicant is in respect of the application, that the accused also need to be. Or, let me just ask, Mr. Hadebe, are you also kind of riding on this application?
It would be prudent for me to do so.
Yes. Mr. Kruvier?
So, yes, you would,
Okay.
my lord.
So the court is going to then recall its order only in respect of the postponement date. The court had, please, I need the accused to understand. The court had previously postponed the matter for trial to the 20th of July 2026. This specifically pertains to Ms. Matlala, accused number 4, who is on bail. The court hereby amends that date. The matter then is postponed in respect of all 4 accused to the 7th of May 2026. At this stage, this is a provisional date. However, Ms. Matlala, you are warned to appear on that date. That's the 7th of May 2026. Are we finally done?
Finally done. My please, thank you, Lord.
Thank you, counsel. Thank you to the court staff. The court adjourns.